Dr. Quang, Kelvin, Radoslav, and Wayne for very good presentation today. We understand that we share the experience from each countries and the codes of conduct, and where the difficulties may come from the payment from the employer to the contractor and contractor subcontractors. Now we are going to take few questions from the audience. Please.
Yeah, I'm Malit Mendis from Sri Lanka.
Hello, welcome.
We have been, thank you. We have been quite engaged in trying to get the government to agree on a Security of Payment Act for the last several years. We even tried to adapt the Malaysian Adjudication and Security of Payment Act from Malaysia to Sri Lanka, to fit into Sri Lanka. But the problem we had is the government's resistance for it. And I think it's the same thing similar to in other developing countries as well. Because I'm also a FIDIC accredited trainer, so I get involved quite a lot, and I'm also an adjudicator and arbitrator. So I get quite involved in payment disputes at regular intervals. What I find is governments, being sometimes the biggest defaulter in payment, are resisting any implementation of legislation with security of payment. So what we try to do is, over the last several years, was to put the dispute adjudication board system in place in most of the projects, including the private sector project. But definitely in the multilateral development bank funded projects, they insist that a standing board be put in place. So we've been trying to follow that so that we have actually the subcontractors and subcontractors do have a system in place where they can go and make a claim about a non-payment and then can get redress. So we've been trying to push that even on subcontracts, especially with FIDIC's contracts. Sri Lankan contracts are very similar to FIDIC contracts, and also trying to use the FIDIC subcontracts on the Red Book and the Yellow Book. The Yellow Book came out recently. So we have been very successful in that way in trying to get a decision from DAB in 84 days. And if there's no notice of dissatisfaction, we go straight to arbitration to get it enforced on a summary award. So that's the way we have found, because of the fact that governments in developing countries are very resistant to a Security of Payment Act put in place. And I can't see any other developing countries, maybe Malaysia is described as developing still, very difficult to find. So maybe Vietnam also can follow a similar system because the governments resist such legislation. Thank you very much. So I'd like to know what your views are on this matter, especially the Vietnamese. Thank you.
Thank you, Malik. Thank you. Very good sharing. Any question or comments from the audience?
I think, if I may, just butt in to comment in response to what Mr. Malith, right?
Malith
has commented. Yeah. So your observation is actually spot on. Even in Malaysia, when they first enacted the act, which was not passed, it was being discussed heavily. What the government's request was that they could pass the act, but it will not apply to public procurement projects. So that was a sticking point, and that got the act derailed for a couple of months until the government finally agreed that the act will also apply to them, and then they got it passed. Yeah, so you're spot on by saying that the government is probably one of the major defaulters in this respect.
Maybe I'll also add a word on Poland, because in Polish reality, I guess, the laws are often passed after like something happens, you know, just like they're remedying what has been seen in construction, for example. And we've had like the direct payment and the mechanisms. Of course, there are like also different mechanisms, some suspension and so on, but we've had these mechanisms for a long time in our civil code, but they've been actually amended just like 3 years ago, following a number of like scandals with like you know, contractors actually not performing, and then with like a avalanche of bankruptcies in the subcontractor area. So I don't know how we should like actually you know, classificate like Polish economy right now. It's probably not already not developing economy, but there was also like something had to happen for the government to act on this matter. Just a just small comment from Poland on this one, but and the floor is yours again.
Sorry, I mute. Now come back.
Okay.
Sorry.
Okay, thanks, Radoslav. The question come back to you guys here for discussion. You know that there are three parties we mentioned today on the link between the client, contractor, and the subcontractor. Here's a story. The client can go bankrupt. The contractor can go bankrupt. And of course, the subcontractor is also maybe going to be bankrupt, not because of the project they are working with, but because of other projects. So our question back to you, to Singapore first. Have you ever seen that happen? And how we can get out from that?
Well, yes, that's, sorry.
Yeah, to Singapore first.
Go on, Kelvin.
Yeah, so it's common, especially main contractors and subcontractors. Clients' insolvency is probably a bit more rare, because before they embark on the project, they would have obtained proper financing. It could be a mixture of debt equity that houses their financing prowess. Main contractor will probably have more sustaining power because they have multiple contracts at one given time. But subcontractors, insolvency is very rampant. One mechanism that it's quite commonly used in the market is the concept of novation. So if, let's say, a subcontractor goes down, there is an opportunity for the main contractor to replace the subcontractor with another subcontractor by way of a novation. Or it could be just a pure termination and getting somebody in at that stage. But for main contractors, insolvency is a bit more difficult to deal with. So typically what happens is this checks on the financial stability of the main contractor is carried out at a very early stage during the tender. So they will have to pass a couple of litmus tests in order for them to be able to obtain that tender. And also they have got to put in guarantees in order to avoid this sort of financial difficulties if it comes. Yeah, that's at least the experience that we have in Singapore.
Okay, thank you, Kelvin. Radoslav, any comment?
Yeah, for sure. So there's actually like, as Kelvin mentioned, the bankruptcies are probably more common with like down the chain of like construction, but that's why we have this like system of guarantees. So as I mentioned, like one is a guarantee of payment, which would normally be a bank guarantee of like insurance guarantee, which would like the bank or the insurer, they would have to pay regardless of whether the company who bought the guarantee actually like you know still exists or is in liquidation and so on. So this is like backed up by a financial institution, which is like, you know, they are very infrequent to fail in this respect. And there is also this other guarantee. So which is like also like in the practice is very common, from the main contractor to the investor for adequate performance. And in case the main contractor fails, he like goes into bankruptcy or liquidation, this guarantee from typically in Poland from an insurer will actually provide investor for money, like some damages to, for example, hire another contractor on the project. This guarantee can also protect, this is not statutory, but it can be contractually done, that this guarantee from the main contractor to the investor can actually secure the payment that the subcontractors, to subcontractors from the investor in case such claim is made. So this like structure of guarantees kind of protects everybody with like kind of like seriousness and stability of financial institutions behind this. Of course, and it has been used numerous times. And actually, for example, this problems with actually enforcing the guarantees, and that they actually worked. So in the Polish context, at least with the Italian companies with infrastructure. So the main contractor was Italian, and we had some of these cases, and they actually terminated the contract, and then the guarantor, which was the insurance company, had to pay for some damages and to subcontractors and so on and so on. Created recently a situation where insurers are not willing to give guarantees to Italian contractors anymore. So this is like this is market reality right now, that it's hard for them to obtain guarantee, which may cause them not be able to participate in public procurement process. But in general, the answer to this is like the structure of guarantees normally protects most of the parties. Okay. And in case of bankruptcy of subcontractor, this is probably the easiest case to manage, because I mean, there's like a number of subcontractors that that the main contractor can pick and choose from. So this is probably the easiest to manage situation in the bankruptcy area.
Thanks. We wish to hear from you, Wayne. It's a lot.
Yeah, I think clearly the bulk of insolvencies are subcontractors, and I think we have a slightly different approach from government here. I think government generally tends to lead the way in fair payment and in shortened payment cycles. I can sort of provide some support to that suggestion that government wants to play its part in keeping people afloat. Back in sort of 2007, 2008, when we had the last recession, I think government were paying within days on invoices from their main contractors. And so our public sector is, to a certain degree, a leader in payment. So there wasn't that resistance from public sector in terms of the legislation. But the problem is the subcontractors. I can remember speaking to a main contractor who was receiving payments, because I asked him, I said, are you getting your payments within days? And I said, no, are you passing it on to your supply chain? He said, oh no, we're keeping them to terms. So as far as that particular contractor was concerned, it's a culture issue. So subcontractors aren't really that well protected, and they're the main sufferers in this, or the victims, I would say. I think I would say the biggest support for the coming period and over the recent years are project bank accounts, whereby money flows directly from a single bank account. I think that for us is going to be key. The difficulty is going to be persuading private clients to do that, and some of the major contractors, because obviously contractors make money by keeping hold of money. But certainly, I think the project bank accounts are a game changer for subcontractors.
Okay, thank you, Mr. Lott. Dr. Quang?
Yes.
Yeah, any comments?
Yeah, your question is about the bankruptcy of the subcontractor due to the payment. I think that it's become problematic when the main contractor cannot get the payment from the client, and even for some, sorry, in some case where the contractor get the payment, but they make use of this payment for another purpose. And again, I think that I'm very interested in the presentation of Kevin talking about this in Singapore or Malaysia. They prohibit that the main contractor put in the contract pay when get paid. If we can, in some sorts, apply this in Vietnam together with the kinds of the payment guarantee, so that we can possibly avoid the problem of the bankruptcy due to the payment. Again, I think that it's become a change of the culture, because the culture is saying that, okay, you are subcontractor, you need to work. You are main contractor, you need to work. So when we are in the discussion with the people in the stronger position, it's difficult to convince them to accept your proposal. But I think that even when Chung, you mentioned about the Decree 37, it's very general. It talks about the way how to show that you have the money to do the project, but they don't force the employer to make the payment guarantee to the work done.
Okay.
If I may, just to follow up on this one, so I fully and 100% agree to this, and this is like for example, the things that Wayne mentioned, that it can be sometimes like done by education, by like creating a contractual scheme that's like protecting the subcontractors. Yes, it can, but like with like this party of negotiation power that's happens all the time between like the investor and main contractor and really small subcontractors in the project, it's immensely difficult, I believe, and also like sometimes like remedies, like possibility to terminate the agreement by the subcontractor or suspend the works by the subcontractor. These are not feasible remedies for them, because they may suspend the work, but they first of all, they actually normally already performed work for month, 3 weeks, 4 weeks, and this is the actual cost they suffered. And also if they suspend the work, then the main contractor will likely the case will move to litigation generally, yeah. And like, of course, there are this like shortened adjudication procedures, but like this is already a dispute when like the relationship between the contractor, main contractor, investor, and the relationship between the parties is not that good anymore. So I have to say that I really like the fact that some of the provisions we have here in Poland are actually like mandatory, and you don't have any workarounds on this, because it doesn't matter on the negotiation power of the parties. The subcontractor can be like a really small contractor, and he will be able to go and ask for the guarantee. He will be able to go directly to the state-owned enterprise to get paid. if for example in a situation when the main contractor files for bankruptcy. So this is just like a final note I wanted to make.
Okay, thank you. We are going to take a question from Mr. Zabao.
Hi, good afternoon. Thanks a lot for your a lot of insight throughout your presentation. Just a quick introduction. Like my name is Bao. I'm used to work in construction before, and before moving to Japan for my education. So basically, I have two questions. First of all, during your presentation, Mr. Minh did mention about the diagram, whether some of the case the subcontractor can request investor to direct pay to them. So basically, I want to ask is in which condition that subcontractor are allowed to request for direct payment, because like we are surely not 100% like subcontractor can request that. Like for example, like $100 million dollar project, and then $1 million subcontractor cannot request that because the amount is super small and it's not work for investor or developer to pay direct to them. So this is the first one. The second one is like more specific in Vietnamese context. So is it any specific laws that allow investor to direct pay to the subcontractor? Because as my experience before, whenever we try to, whenever we see a delay in the payment from main contractor to subcontractor, we are try to advise and talk to main contractor whether we can pay direct to them. But main contractors seem like not really agree, because they said that developers should not interfere in their payment control. So that's why I'm asking, like, whether we have really specific laws that allow investor legally pay direct to the subcontractor. Thank you.
Radoslav?
Okay, so yeah, sure. So quickly addressing the first question, like the second I will refer to other speakers. But like with the first question, it actually is like this. There's like the only requirement that there is to this. It's joint and several liability, which means if you have like two parties, A and B, jointly and severally liable, you can pick and choose with your discretion whom you actually make the claim from. So they don't like in like by the theory of law, you know, by fact, you could actually go directly to the investor, not even asking the main contractor for the money. And the requirements, of course, there are limitations to it, but they're very, very small ones. Like there's like this notification requirement. So the investor, it would have to know about the contract with the subcontractor. It can be, but for example, sometimes already in the contract between the investor and the main contractor, it's already like specified that they will be using subcontractors, and this will, for example, be enough for the notification purposes. The limitation of liability of the investor will be like the amount would be limited to the actual remuneration owed to main contractor. Yeah. So if the investor has a project for 100 million, he wouldn't be liable for 150 towards subcontractor. But there's definitely no limits. Like the subcontractor is small. If he has like $20,000 claim to the main contractor, and the big contract is for 100 million, that doesn't matter at all. Like he can go directly to the investor. And I hope that is answers your question.
For the second question, I would like to share the experience we had recently in one project in Hanoi where I work from the employer side. We prepare the contract with the main contractor who are in charge of the full building, but they have some subcontractor for facade, for MEP, lift, etc. We foresee that in some case, the main contractor, for some reason, may not pay on time the subcontractor. This will affect the schedule of our project. That's why we have the clause that after 5 working days, where the client or the employer already paid, the main contractor, if the contractor cannot provide the evidence that they have paid to the subcontractor, the client, the employer have the right, not obligation, but have the right to pay the subcontractor for the amount due, and not only deduct from the next payment from the main contractor, but also to claim the contractor for any delay or any damages caused by their delay of the payment to the subcontractor. And I think that we can avoid that the main contractor say, no, you don't interfere in our affair.
Dr. Kwang,
Yep.
a small further question to you.
Yep.
You mentioned about the main con and the subcontractor for facade and stuff. Are they nominate subcontractor or they are just a subcontractor as common?
Yeah, actually, we disclose for the payment direct to the contract to the main contractors is applied to both NSC, nominated subcontractor, or the subcontractor chosen by the main contractor, because we don't want that for any reason the main contractor will get the payment and won't pay to the subcon and get the delay to the project.
All right. To Mr. Bao, I can confirm with you that under the construction law, under any ordinance or decrees under the laws in our country, subcontractor have never been mentioned ever. So they are disappear. Because our tender law, especially for the public sectors, is prohibiting, we call the selling the works out. That means that when a man can't get a job, they sold out the job and they don't do anything. The nature of our laws right now, I assume, is going to be, they have to change very soon, because the major part of the job that normally taken by any main con are going to be subcontract anyway. Some way, somehow, like concrete suppliers, facade, bricklaying, tiling, and our laws impose that if the main con subcontract out 30% or more, they can be justified as illegally acting against the budget laws. So I do believe that if by the speakers today, we can summarize some very good ideas on the question that you have raised. We need to change the law in Vietnam when we might come back to this very good topic, that when subcontractor can be paid by the contractor and how they can be guaranteed by laws, because we have no guarantee at all. Thank you. Any other question?
Yeah, thank you very much for your answer.
Mr. Chung?
Yeah. Hello, everyone. We are looking for more questions from the audience. We have about 10 minutes left. Yep. So welcome our question. English or Vietnamese, okay. Vietnamese, we have the translator here. Looking for one question, but